Lots of us have left a goofy message in the reference field when paying back a friend. But now there's evidence perpetrators are using their victims' bank accounts to harm or intimidate them, especially when they've been blocked from other kinds of contact.
If you've actually said to this person, look, I don't want to be in a relationship with you anymore, and you've blocked their calls and tried to stop contact with them, they might use every opportunity that they can to connect with you and to actually harass you and abuse you. And one of those ways might be by using the bank transfer message field.
It's called transaction abuse, and recent analysis by BNZ showed 10,000 potentially concerning examples over a period of 6 months.
We had a customer who unfortunately was sending money to what was clearly an ex-partner, pleading with this individual to get back, but going through the cycle of abuse. So I love you, through to I hate you, through to I want to get back with you, and actually sent $2.36 over a 6-month period through 90 different messages. So when we come across individuals that have received these payments, we'll check in on them. And we need to make sure that they're, more often than not, if we identify the abusive transactions, again, the context may be that they're actually okay, but if they're not okay, this is maybe actually the tip of the iceberg to what's going on in the situation. So we always want to make sure that they're safe. They contact police, they contact support services, and then we make sure we follow up with those people.
Well, family lawyer Kezia Denhart wrote a paper about this for the New Zealand Law Society. Kezia, how widespread is this problem?
Unfortunately, it is becoming increasingly common in my practice. I'm hearing from my clients all the time now that perpetrators, their former partners, are being abusive by using the bank references. For example, I've had a number of cases recently where my client has reported that their former partner has been transferring funds to them that are required from them by way of financial support, and using that opportunity to say things like, I miss you, or I love you, or I will see you soon, and things like that, which, of course, in the context of a family violence relationship, are incredibly disconcerting and alarming for that person.
This feels like another case of the law just not keeping up with technology. What can we do to stop it?
I think what we need to make sure of, what in particular, as I said, the financial institutions themselves need to do, is ensure that they deter and discourage this sort of behaviour. It could be that there are some processes that the banks can employ to ensure that these sorts of references are picked up, and then there's some sort of reporting function so that it can be escalated and action can be taken. But fundamentally, and I think above all else, financial institutions need to listen to their customers as part of their customer care and ensure that they do whatever is within their power to help and support these customers.
Out of interest, as a lawyer, can you use this stuff as evidence? Can you take a bank statement to a judge and say, hey, look what this guy's doing?
Absolutely, you can and should, and that will be the best evidence, and it cannot be disputed, of course, because it is in print. So that should be the evidence that you use in support of any application for protection order under the Family Violence Act, or any applications that you make under the Harmful Digital Communications Act.
People are outrageous, but do you have any advice for people that are being targeted in this way?
Certainly in the first instance, they should notify their bank if they haven't already been alerted to it by the financial institution or bank themselves. If that hasn't borne any fruit for them, then they should enlist the assistance of a lawyer. It may be that they have options that can be exercised under the Family Violence Act or the Harmful Digital Communications Act. And if the activity has occurred with criminal intent, it could be a criminal offence under the Harmful Digital Communications Act.
Well, Kezia, thanks so much for your advice tonight.
Thank you for inviting me.
Okay, so that actually blows my mind because, as I said in the intro, we all do a silly little reference word, right? Like you guys, we all do it, don't we?
Joke ones, yeah.
Yeah, but I wouldn't have thought of this as being a way to target people, but I guess every app and every piece of technology now, I mean, you think of things like Strava, you know, when you go for a run and stuff, you can still... Fitness. Yeah. You familiar with that?
I'm not familiar with Strava, no. It's a fitness app,
but you know, like I mean, I'm always really aware not to put my maps up where I'm running and things like that, but also, you know, you can abuse people via these apps as well. So I think the key probably is to make sure the bank's reporting systems are potentially more rigorous than they already are.
Yeah, and just those big institutions and like lawyers and stuff understanding that anything in the wrong hands can be used against them. I'd shudder to think someone that wasn't with BNZ, obviously BNZ are across it, but they went to their bank and their bank said, I don't know what you're talking about.
For sure.